India Legal presents Courts Roundup.
Hello, I'm Misha and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceeding. And before we begin, here's the headlines. The Supreme Court stays order of the Gwalior bench of the Madhya Pradesh High Court restraining physical gathering during election campaigning, says parties can approach Election Commission. Supreme Court dismisses plea seeking 50% reservation for OBC candidates in admissions in Tamil Nadu government medical colleges. In a relief to small borrowers, the centre said in Supreme Court that it will deposit differences between compound and simple interest in borrowers' account by 5th of November. And in Jharkhand Coal scam case, Ex-Minister Dilip Ray and two senior officials of the Ministry of Coal awarded 3-year jail term by Delhi court. And as a first in court history, Gujarat High Court begins live streaming of Chief Justice courtroom proceeding from today.
India Legal presents Courts Roundup.
The Supreme Court on Monday stayed an order of the Gwalior bench of the Madhya Pradesh High Court of October 28 restraining physical gathering during election campaigning by candidates in by-election to 28 seats. The order came on an appeal filed by the Election Commission, which said that the High Court order paralyzed election process with few days remaining for the election on November 3rd. But the Apex Court has also pulled up the EC for not taking a proactive role to enforce COVID-19 protocols at the election rallies that led to High Court order. The top court added that it will be open to the parties to invite the attention of the Election Commission in conduct of elections in a free and fair manner. The bench further stated that it had no reservation on staying the order, but the ECI must take cognizance of the issues that had come up before. A bench of Justices A.M. Khanwilkar, Dinesh Maheshwari and Sanjeev Khanna passed the stay order in 3 separate pleas by Election Commission of India and BJP leader Pradyumna Singh Tomar and Munna Lal Goyal, challenging an order of the Madhya Pradesh High Court imposing conditions in conducting physical gatherings by political parties for campaigning in assembly by polls. The High Court had directed all campaigning to be held virtually, and permission for physical gathering was to be given by district magistrate. Only a virtual mode was impossible. Any such permission by the DM was to have the EC's approval, and the candidate was asked to deposit money that is sufficient to purchase double the number of masks and sanitizers for those attending the event. A 3-judge Supreme Court bench headed by Justice A.M. Khanwilkar, while granting stay, told the EC that had it taken a proactive role in enforcing the COVID SOPs of social distancing, the High Court would not have interfered in the matter. The top court said, "You should have intervened at the appropriate level and asked government to take steps. At public meetings, you should have ensured SOP was followed and those candidates who were found to violate ought to have been issued notice. We wish you were proactive to supervise election better. If parties maintained protocol, this situation would not have arisen." The bench left it to the EC to take a call on any such representation that is moved by candidate or political parties, while the Election Commission had assailed the order on the ground that the conduct and management of elections are overseen by it under the Constitution, and Article 329 of the Constitution puts an express bar on judicial interference in midst of electoral process. BJP candidate Pradyumna Singh Tomar, contesting by-election from Gwalior, had moved the top court through advocate Asta Sharma, contending that the impugned interim order had violated his right to conduct election campaign through physical gatherings as permitted by the Election Commission, the central government and the state of Madhya Pradesh. Bureau Report. The Supreme Court has turned down a batch of petitions, including by the Tamil Nadu government seeking 50% OBC reservation in Tamil Nadu for all India quota seats in state-run medical colleges this academic year. The petitioners were heard by a bench led by Justice L. Nageshwar Rao. Tamil Nadu government ruling AIADMK and DMK had moved the top court after the centre had said that it was not possible to extend 50% OBC reservation this year. The High Court on July 27th had directed the central government to constitute a committee comprising representatives from the Centre, State and Medical Council of India to decide on the issue of providing OBC reservation in all India seats surrendered by Tamil Nadu for medical admission. The court, however, had also said that any decision of the committee would be applicable only for future academic years and not this one. The parties throughout the hearing had contended that the central government is only an agent and a counselling authority to fill the seats according to the reservation. Earlier this month, the centre informed the top court that it is not possible to extend reservation benefits to OBCs in medical seats under AIQ in Tamil Nadu this year. Centre has filed its reply in the Supreme Court in the loan moratorium issue. Centre has informed in its affidavit that the difference between compound interest and simple interest will be deposited in the account of borrowers by November 5th. The affidavit comes after Supreme Court had pulled up the Centre for delay in implementation of their decision for providing benefits to small borrowers. The central government has filed a detailed affidavit before the Supreme Court in connection with the loan moratorium case, stating that the difference between compound interest and simple interest will be deposited in the account of borrowers by 5th November. This decision was taken by the Ministry of Finance and has been approved by the Union Cabinet in its meeting held on 21st of October. The Centre said in its affidavit that the Ministry of Finance has approved the policy of interest waiver scheme for borrowers of specified loan for a period ranging from March 1st to 31st of August. The bench of Justice Ashok Bhushan, R. Subhash Reddy and M. R. Shah had heard a batch of petitions raising issues pertaining to validity of RBI's 27th of March circular, which allowed lending institutions to grant moratorium on payment of installments of term loans falling due between March 1st, 2020 and 31st of May this year due to the pandemic. The amounts shall be credited by each of the lending institution, irrespective of whether such eligible borrowers have fully availed or partially availed or have not availed of moratorium such as deferment in payment of installment, the affidavit stated. The affidavit submits that the decision came to be approved by the Cabinet on 21st of October, and pursuant to this approval, the Finance Ministry has now issued the scheme. As per the scheme, the lending institution will credit the difference between compound interest and simple interest for the 6-month period in respective accounts of the borrowers, irrespective of whether the borrower has fully or partially availed the moratorium announced by the Reserve Bank of India on 27th of March 2020 on the repayment of loans. The affidavit comes after Supreme Court had pulled up the Centre on 14th October for its delay in the implementation of their decision for providing benefits to small borrowers who had taken loans of up to 2 crore rupees. The Supreme Court is scheduled to hear the loan moratorium petition seeking a direction to waive interest on November 2nd. Bureau Report. And the Supreme Court has kept in abeyance the order passed by it on October 16 to appoint Justice retired Madhya B. Lokar, former SG judge, and as a one-man panel to coordinate and monitor the steps taken to tackle the problem of the stubble burning. A bench headed by the Chief Justice of India, S.A. Bobde, passed the order on Monday based on a request made by the Solicitor General of India, Tushar Mehta. The Solicitor General submitted that the central government was bringing a comprehensive legislation to set up a permanent body to address the problem of stubble burning. In that view of the matter, the Solicitor General urged the bench to keep in abeyance the October 16 order appointing Justice Madan B. Lokar. Justice Lokar, since his retirement as a judge of the top court in December last year, has been fiercely vocal in criticizing the Supreme Court on many issues, such as the handling of migrant crisis, a delay in hearing important constitutional cases, etc. He had also expressed disapproval of the Supreme Court punishing advocate Prashant Bhushan for contempt of court, and Justice Lokar has also expressed concern at the increasing use of sedition law, UAPA, and preventive detention against dissent of the government. And former Union Minister Dilip Ray was on Monday awarded a 3-year jail term by a Delhi court in a coal scam case pertaining to irregularities in the allocation of a Jharkhand Coal block in 1999. Special Judge Bharat Parashar also awarded 3-year jail term to two senior officials of the Ministry of Coal at that time, Pradeep Kumar Banerjee and Nityanand Gautam, and Castron Technological Limited Director Mahendra Kumar Agarwal. Former Union Minister Dilip Ray was on Monday sentenced to 3 years imprisonment in a coal scam case. Ray was convicted in the case which pertains to irregularities in the allocation of a Jharkhand Coal block in 1999. A Delhi court had earlier this month reserved the order for October 26 after hearing arguments from the Central Bureau of Investigation as well as the convict. The court directed the convict to be present before it physically on that date. Besides Ray, former Minister of State Coal in Atal Bihari Vajpayee's government, the CBI had sought life imprisonment for other convicts. Two senior officials of the Ministry of Coal at that time, Pradeep Kumar Banerjee and Nityanand Gautam, and Castron Technologies Limited Director Mahendra Kumar Agarwala. The court also imposed a fine of 10 lakh rupees on each of them. The court further imposed 60 lakh rupees on CLT and 10 lakh rupees on Castron Mining Limited, also held guilty in the case. Ray was convicted under various sections including 409 of the Indian Penal Code, which pertains to criminal breach of trust by a public servant. I am very surprised at conviction under Section 409 of the IPC, as the same court in the past had acquitted people in 409 IPC in view of 3-judge bench judgment of Supreme Court. However, I welcome sentence not being harsh of 3 years having been imposed by the court, said Vijay Agarwal, advocate who represents various accused in 2G scam and is also representing various accused in coal scam case. This was the first conviction in the coal scam. The judge had said that Ray dishonestly facilitated allocation of abandoned, and that too in violation of direction of law. The case pertains to allocation of Brahmadiya coal block in Giridih in Jharkhand to CTL in 1999. Bureau Report. In a first-of-its-kind decision, the Gujarat High Court has begun live streaming proceedings from Chief Justice Vikram Nath's court from Monday onwards. Proceedings before the bench headed by the Chief Justice is being streamed on YouTube, and in its press release, the High Court has referred to a Supreme Court judgment which ruled that the public should be allowed to view court hearings conducted through video conferencing. The communication also references PIL filed by Nirma University School of Law students Prithviraj Sinjala that sought the court to issue direction for live streaming court proceeding to keep with the principles of open court and access to justice. Taking note of the statutory framework, the Delhi High Court has stated that it is necessary for the intermediaries, that is social media platforms, to take all effective measures available with them to ensure that the child porn content is not hosted on their platforms. The order was passed by a single judge bench of Justice Bhibu Bakru. The petitioner, a young woman, had become acquainted with a boy, the accused, when she was in school. As per the petitioner, her relationship with the accused was very abusive, and he even compelled her to send her intimate photographs to him. Later, she broke up with him, and after the petitioner moved to Melbourne, Australia, she became aware that the accused had posted her intimate pictures on various platforms such as Twitter, Instagram, YouTube, etc. The petitioner filed a complaint against the accused before the Special Cell Cybercrime Department, Delhi Police, and also filed the present petition seeking direction to Facebook, Google, and YouTube to remove the objectionable content. In view of the submission, the court held that there was no dispute that the intermediaries would be required to take down or remove unlawful content on receiving information regarding the same. Madhya Pradesh High Court has remarked that in the hierarchy of justice administration, at no level can the court be held hostage to the shrill screech of a public perception. The day that happens, no longer would it be said that the court are impervious to influence. The bench of Justice Atul Sridharan made the aforementioned remark while hearing the bail application of two real brothers who are alleged conspirators to or accessories before the fact of the crime, wherein an under trial Iqla Qureshi was murdered in the premises of the district court Chindwara by three assailants when he was produced before the court below on a remand hearing. As regard one of the two accused, the bail applicant Narendra Patel, it was alleged that he harbored a motive to kill Iqla Qureshi, as earlier deceased Iqla Qureshi had attempted to murder him. It was in the case relating to the attempt on the life of applicant Narendra Patel that Iqla Qureshi was being produced before the court before as an under trial that he was murdered. The court noted that the applicant have already completed more than 3 years as under trials, and the evidence against them was of being involved in the conspiracy to commit the murder of Iqla Qureshi. We are now joined by Advocate Shivam Sharma for more updates on this.
Yes, in this case, the court said that merely because the case has generated much heat in the public domain and has been widely discussed in the media cannot be a consideration for the court while deciding a bail application. The court also observed that if the process of trial is impeded for no fault of the accused, and there is an excessive delay on account of the prosecution being unable to produce the witness for whatever reason. The court, in this case, further observed that it has to balance both the rights of the accused against inordinate incarceration as an under trial and issue that is ability to influence witness while once on bail. Therefore, the court has allowed the bail application of the.
Thank you, Shivam, for the update. Moving on. The Supreme Court has asked the petitioner seeking a Central Bureau of Investigation probe into the death of late actor Sushant Singh Rajput's former manager Disha Salian to approach the Bombay High Court. The bench of Chief Justice of India S.A. Bobde and Justices A.S. Bhopana and V. Ramasubramanian stated that Bombay High Court was hearing several such similar cases and that it was well acquainted with the evidence and the officers investigating the case. However, the bench also observed that the petitioner can still approach the apex court if not satisfied with the High Court's order. The plea states that both Rajput and Salian died under suspicious circumstances and at a peak of their successful professional careers, and as per the statements of witnesses, and they both were upset as some projects of them were sabotaged and taken back from them, and some of the projects were not working out and many were getting cancelled or delayed. A Singapore-based single-judge arbitration court had restrained Future Retail from selling its retail business to Reliance Industries for rupees 24,713 crore. And after the order, Reliance said that it intends to enforce its right and complete the transaction in terms of the scheme and agreement with Future Group without any delay. Reliance Industries has planned for the online segment that would see it take on Amazon. Reliance Industries a deal to acquire rival Future Group's retail businesses, and coupled with its launch of JioMart earlier in May, were aimed at revealing Amazon local unit and Walmart's Flipkart in the huge retail market in the country.
Reliance Retail said its intent to enforce its right and complete the transaction as per its agreement with the Future Group without any delay, after the US-based e-commerce major Amazon.com won an interim award against Kishore Biani-owned group company for its deal with Reliance Retail Ventures Limited. The Singapore-based single-judge arbitration had restrained Future Retail from selling its retail business to Reliance Industries for 24,713 crore. The indebted Kishore Biani Group company had earlier signed a pact to sell its retail, wholesale, logistic and warehousing unit to Mukesh Ambani Reliance Industry through its subsidiary Reliance Retail Ventures. Passing an interim award in favor of Amazon, V.K. Raja asked the Future Group to put the deal on hold and said that the deal cannot go through until it finally decides the matter. Reliance Industry retained arm Reliance Retail Ventures Limited said it has been informed about the interim order passed by the emergency arbitrator in the arbitration proceeding and intends to complete the transaction with Future Group without any delay. RRVL has entered into the transaction for acquisition of assets and business of Future Retail Limited under proper legal advice, and the right and obligation are fully enforceable under Indian law. RRVL intends to enforce its right and complete the transaction in terms of the scheme and agreement with Future Group without any delay, Reliance Retail said in a statement. The ruling mark provides some respite for Amazon as it seeks to halt a deal that could give Ambani dominance in the race for the country consumer retail market. Reliance Industries, already the country's biggest brick-and-mortar retailer, has planned for the online segment that would seek take on Amazon in what it a rising market, we report.
And that's all for Coast Roundup. Thank you for watching.
India Legal presents Courts Roundup.